Right. It's 7 o'clock. I would like to call our meeting of the Board of Adjustment to order. Um, Thanks to Patty for the well-prepared material. Very nice. Like to entertain a motion to approve the agenda.
Motion to approve the agenda, sorry.
All in favor?
Aye.
Agenda approved. Minutes of our last meeting of June 9th. Like to entertain a motion to approve the minutes.
I'll make a motion to approve the minutes.
Second.
All in favor, say aye.
Aye.
Minutes approved. Public comments.
We've received one public comment by email, and if it's okay with you, I'll go ahead and read that into record.
Yes, please.
Opposition to variance request VAR 2605. Dear members of the Board of Adjustment, I'm writing as a property owner located at 8014 Boston Highway to formally express my strong opposition to the variance request for my adjacent property. The applicant is requesting a massive 38,200 square foot variance from 154.066 L1 of the town zoning code to allow a non-residential building size of up to 53,200 square feet in the Mills River mixed-use residential mixed-use zoning district. The current zoning ordinance establishes a maximum non-residential footprint of 15,000 square feet for good reason. Allowing a building that is more than 3.5 times the legally permitted size fundamentally contradicts the intent of the Mills River mixed-use district and sets a concerning precedent for future development. Specifically, I urge the board to deny this request based on the standard legal criteria required for granting a variance. Inconsistency with the intent of the ordinance. The Mills River Mixed-Use Zoning District is designed to foster a balanced neighborhood scale development that integrates harmoniously with surrounding residential areas. A 53,200 square foot commercial structure is massive in scale and belongs in a heavy commercial or industrial district, not adjacent to residential properties. Lack of unnecessary hardship. A variance is meant to provide relief from unique physical conditions of the land, such as topography or partial shape, that prevent reasonable use under current zoning. Seeking to construct a building over 350% larger than allowed is a self-created financial or operational preference of the developer, not a hardship inherent to the land itself. Negative impact on adjacent properties and community character. Approving a structure of this magnitude will significantly increase traffic congestion, noise, light pollution, and stormwater runoff, directly impacting neighborhood property values and the overall quality of life for surrounding residents. The existing 15,000 square foot limit provides ample opportunity for reasonable scale, appropriate commercial use of the property. Approving a 38,200 square foot variance would effectively undermine the town's comprehensive planning goals and subvert the zoning standards enacted to protect our community. Thank you for your time, consideration, and dedication to maintaining the character and integrity of Mills River. I respectfully request that the Board of Adjustment deny variance request VAR 2605. Sincerely, Nicholas Cronk and Madison Russo at 8014 Boylston Highway.
Thank you. We have a lot of people that have signed up for public comment, but I think that we would like to propose to have the public comment limited to, what's the term? People with standing for the specific application, or do we do it all first?
I think, Paul, it's been standard for this board to allow public comment. I think the public comment will have to be taken since it was noticed.
Okay.
It had been done. However, I will remind the board, and in fact, I'll remind the audience as well, nothing that is said in public comment may be taken into consideration whatsoever by this board, because it's not evidence before you. It will have to be ignored. But you can certainly listen to it. That changes anybody's mind about what's been speak or not, then so be it. But
Okay, all right.
public comments allowed, needs to be allowed, but you are not to consider it in any way in making any decision.
Can we put a time limit to public comment?
3 minutes is the.
Okay.
Public comment.
All right. Well, then, let's go through the list. Kathy Heck, 279 Snyder Lane.
I live next door, but I don't know the side of the property. This is, the public,
B.
I believe that this was, public comment is just for making public comments
Yeah.
about what's going on, each specific variance request, because this is a quasi judicial proceeding, it's going to have to be addressed individually without any recognition of any of this public comment. If there's, someone has a comment they wish to make about general size restrictions, then they can make a general size restriction comment, but that really shouldn't be taken into consideration for any particular thing that you're listening to at this.
Okay. So right now, we start with public comment. Please go ahead. You get 3 minutes.
My name is Kathy Heck. I live at 279 Snyder Lane in a residential neighborhood directly across the street from the proposed site on Boylston Highway. I have several concerns about this application for a variance. Number one, the background section of the staff report regarding this hearing includes the statement that the 15,000 square foot maximum building size, quote, creates unnecessary hardship by limiting the project's economic feasibility and marketability, unquote. There would certainly be cost savings in constructing 2 buildings rather than 6. However, cost savings and marketability are not included as reasonable grounds for granting variances to zoning code regulations. It's also misleading to say that the revised proposal represents a reduction of 10,200 square feet compared to the original, because it described and included potential building addition for building 2 would increase that structure's overall square footage to 53,200 square feet, which would increase the combined square feet of the 2 buildings to a higher number of square feet than the original proposal for 6 buildings. Again, cost and marketability are not considerations when deciding whether or not to grant a variance. Number 2, the applicant claims hardships unique to the property are 2 perennial streams and poor soil conditions. For a variance to be issued, a hardship common to the neighborhood or the general public, quote, may not be the basis for granting a variance, unquote. As a nearby property owner, I can say with certainty that our neighborhood is full of streams and poor soil. If the same bore sampling was to be done on adjacent properties, my guess is that similar findings would be discovered. Number 3, the applicant contends the required variance is consistent with the spirit, purpose, and intent of the ordinance. I disagree. The ordinance establishes 15,000 square feet as the maximum building size, and a single building more than 3 times the maximum allowable size.
30 seconds.
Okay, as that named by the ordinance is not in keeping with the site's rural nature and will not more effectively blend with the natural setting. The hardship resulting from the strict application of the regulation appears to be more closely tied to cost and market forces than to the issues directly related to the land. Thank you for the opportunity to voice my concerns, and I appreciate your service to our community. Thank you.
Thank you. Next, Kendall Heck, 281 Snyder Lane.
My name is Kendall Heck and I live, and my family lives on Snyder Lane down the road from her, directly across from Boylston Highway on the proposed development. And I'm here because the project will directly affect my family, my neighbors, and because I believe as citizens, we have the responsibility to pay attention when expectations are requested from the rules that our town has put in place. I've spent a great deal of time reviewing the town's staff report, the applicant's material, the previous site plans, the town's correspondence, and my concern is simple. The applicant has clearly explained why larger buildings would be cheaper, easier to market, and more flexible. But I have not seen evidence to explain why the physical condition of this property actually requires buildings that are larger. The town allows a maximum, which we've heard over and over, of the 15,000 square feet. The current plan shows two 39,900 square feet buildings with a possibility of an addition, which would be 53,200 square feet. That's more than 3.5 times the town's current limit. The town staff report says the application claims that the current limits affect the project's economic feasibility and marketability, and identifies approximately $646,000 in building construction savings from building 2 large buildings instead of 6. But the same record shows that back in December of 2024, the applicant submitted a plan for 6 15,000 square foot industrial buildings on the same property. So the question is, if the plan is using the town's existing building size limit, which previously was proposed here, what evidence now shows that the following that limit creates unnecessary hardship rather than simply a more expensive or less desirable business outcome? The applicant also relies on poor soil, high groundwater, streams, drainage, septic limitations as part of this hardship. But in the public material available to me, I've not seen clear explanation of why those physical conditions require a larger and heavier building on this vulnerable land. Town staff itself raised the distinction, saying documentation was important to demonstrate a unique hardship and quote, versus just requesting the variance for financial feasible reasons. This is the heart of my concern. Where is the evidence connecting the physical hardship of this land to the need that is specific for increasing this building size? If the evidence presented tonight does not establish all four of the required findings, I respectfully ask the board to deny the variance on this property for 26-05. Citizens may not be able to participate in the hearing itself, but we're paying attention. And we can read the record, we can understand the standards, and we can anticipate an expectation to this large building be shut down unless it corresponds with all 4 hardships. Thank you guys for listening. And I have to go put my children to bed before the first night of school.
All right, next, Mr. Eric Young, Broadbridge. Okay. Next,
If you're the applicant, withstanding, you will be sworn in, and participate in the hearing.
that's fine. Jeremy Ross. Okay. Michael Sykin. Nick Harkins, same thing. Okay, all right.
And the same for like.
Jay Awald, same. John May. Cameron Morty. Steve Adams. General comment? Please come to the microphone. You got 3 minutes.
Oh, parking lot. I own the property right next door, the southeast. And as you know, we had tremendous flooding there. The southeast side of that property, the south side of the property facing east. Also is floodplain on this particular property, as I suspect that you know. My concern is the size of the building, 3.5 times bigger than the variances, that everybody said. And my understanding is this is a church to be built. Is that correct? And that's why I'm asking, that's why I asked if you would cover some of this before we even had public comment. Is that correct? It's church?
It's really not a time for question and answer.
No.
It's time
Well,
to
you could have,
You-
you could have avoided a lot of, you know.
Sir, you
pub-
can make your
activity. I'm
public
making a
comment.
Public comment. I'm making a
Thank you.
public comment, is if you had reviewed, this is gonna be such, so this is what's planned. You know, and the sign previously, several months ago, said it was gonna be a church. And I was told that by the gentleman that sold the property as well. So, you know, church is fine, but it shouldn't be 53,000 and another building of that size. That's 1 1/5 acres just in building. And what's that gonna do? The water runoff into an area that's very flood prone. And it floods from 1 to 3 times every year over the last last 10 years. So, you know, I have to oppose that. I mean, wouldn't say that a larger building couldn't be constructed other than 15,000 feet, but, you know, I'm right next door and I want to be a part of it and I want to be in favor of what's going on there, but 3.5 times. To your comment, if they're not to listen, if they're to ignore anything here, why are we even here?
This is a quasi judicial proceeding, sir.
I'll take care of it.
Thank you, Matt. Sorry.
Yeah, this is a quasi, this is like Portland. They can only consider evidence that's been sworn to and presented in an appropriate legal manner. Anything that's done in public comment that's not sworn to, is not in a legal manner. I'll just remind you that essentially anything that's been said, including comments about flooding or size or anything like that, what was there before, you have to put out of your mind in order to have a clean, proper quasi judicial procedure.
In other words, law doesn't want them to take on things that might be of importance that they haven't thought.
If you have prove, then you're welcome to ask for standing, and it's legally, when the hearing comes up with you. You're more than welcome to ask for that. There's precise legal definition. It will go along to you.
Next, Matt Bird. Okay, good. All right. Next, we go to our motion. We do that later, right? Motion to open our evidentiary hearing for variance application 2604.
So moved.
A second.
All in favor?
Aye.
Right. Variance application, variance 2604, a request for a variance from section 154047 G6 and 8, front yard setback and side yard setback in Mills River Low Density Residential MR30 zoning district. This is a quasi judicial evidentiary hearing. That means that it is like a court hearing. North Carolina state law sets specific procedures and rules concerning how this board must make its decision. These rules are different from other types of land use decisions like rezoning cases. The board's discretion is limited. The board must base its decision only upon competent, material, relevant, and substantial evidence in the record. A quasi-judicial decision is not a popularity contest whereby opinions are considered. It is a decision constrained by the standards in the Mills River Code of Ordinance and based on the facts presented. If you will be speaking, please focus on the facts and the ordinance standards, not personal preference or opinion. Participation in this hearing is limited. This meeting is open to the public. Everyone is welcome to watch. Parties with standing have rights to participate fully in the hearing. Parties may present evidence, call witnesses, and make legal arguments. Parties are limited to the applicant, the town of Mills River, and individuals who can prove they will suffer special damages as a result of this decision. Other individuals may serve as witnesses when called on by the board. Witness testimony should be limited to facts and not opinions. General public comment is not permitted during the hearing. All witnesses must swear or affirm their testimony. In one moment, the clerk will administer oath for all individuals who intend to act as a witness or provide testimony. Recognize any person wishing to petition the board to act as a party with standing.
Mr. Chairman, you probably need to ask if there's any personal knowledge.
Yes. I skipped that one. Any board member with personal knowledge upon that you may rely on that is not in the record, site visit, internet research, talking to applicant or neighbor.
I have no knowledge, but I am friends with one of the adjacent property owners, but we have not discussed the issue or anything.
We all live in the town. We all know
Just
people.
making sure.
Mr.
Thank you.
Chairman, on each application, I looked at county GIS for an aerial, turned on contours and stuff. Not done any site visits or had any ex parte communication.
Right now, recognize for this specific case, any person that wishes to petition the board to act as a party with standing. And let me just read out what that means. Standing gives the person special rights in the hearing, cross-examination of witnesses, making motions or objections, and challenging the impartiality of a board member, and appeal the decision. To be a party with standing, the person must prove legal interest in the subject property, or they will suffer special damages, or they are a homeowners association or neighborhood community association not formed in response to the case at hand. Who do we have right now beside the applicant?
I would imagine we need to swear, Mr. Chairman, the applicant
Mhm.
and the town.
Yeah.
To provide testimony and then see if anyone else wishes to seek standing in this particular variant.
I need to read which one that is.
Okay. Well, did we, I just read that one. Variance 2604, from the side yard setback in Mills River Low Density Residential District. And that is, identified as 74 Pisgah Ridge Trail. Correct?
Correct?
Who is the applicant is Jeremy Ross. Would you mind coming up?
And for the town, we have Ken Webb, our planner, and Michael Malachek, the planning director. He's attending via Zoom.
There he is.
And before swearing in, we need, for those with standing in the hearing, we need confirmation that they're okay with Mr. Malchek participating remotely. Or is the applicant okay with that, board?
Right. Okay, what's his name? Okay, raise your right hand, please. Do you swear to tell the truth, the whole truth, and nothing but the truth to help you God?
Okay. We would like to recognize planning and zoning staff to present the case and enter preliminary materials into the record. First. Yeah.
Sorry.
Just wanted to let the board know that if you need any of the attachments on the TV, since I'm here and not over there, just let me know and I'll be happy to pull it up. So for the staff report for variance request 2604, the Board of Adjustment will hear a request of Jeremy Ross, owner of the property identified as 74 Pisgah Ridge Trail, located in the residential subdivision, The Farm at Mills River. The request is for a 25-foot variance from 154.047 D6, the town's 60-foot minimum front yard setback requirement for principal buildings within the MR 30 residential zoning district. As well, there is a request for a 10-foot variance from 154.047 D8, the town's 30-foot minimum side yard setback requirements for principal buildings in the low density MR 30 residential zoning district. If both variances are granted, it would reduce the front yard setback to 35 feet measured from the front property line. And it would reduce the side yard setback to 20 feet measured from the side property lines. So, just a background, Jeremy Ross submitted, the property owner submitted a complete and paid variance application on July 8th, 2026. The applicant contends that the strict application of the 60-foot front yard setback and 30-foot side yard setback requirements created unnecessary hardship due to the location of existing stormwater drainage features and discharge outlets along the northern and rear property lines of the subject property. Per the applicant, compliance with the required setbacks would involve constructing the single-family dwelling in an area where stormwater discharges across the property. The applicant asserts that reducing the front yard setback by 25 feet from Pisgah Ridge Trail would allow the residents to be located farther away from the stormwater runoff discharged area, and also reduce the potential for water accumulation near the proposed home site and future building foundation. Additionally, the applicant states that reducing the required side yard setback by 10 feet adjacent to Double Knob Road would allow the proposed residents to be located farther away from the existing stormwater drainage channel and riprap situated between the subject property and the neighboring property at 46 Pisgah Ridge Trail. See attachment H for the applicant's project narrative and justification, as well as photographs depicting the stormwater runoff during a heavy rain event. The applicant states that the hardship is unique to the property due to its topography. The applicant contends that the property's topo contours direct stormwater directly across the middle portion of the property, where residents would otherwise need to be constructed in compliance with the ordinance setbacks, and absent of the variance request approvals. The applicant further states that the adjacent property sits at a significantly higher elevation than the subject property, resulting in stormwater flowing towards the proposed building site, as shown in attachment E, which is the site plan without an approved variance. Per the applicant, these site conditions create a unique hardship because the location, as shown on attachment E, would be directly affected by concentrated stormwater runoff if the variance is not granted. The applicant also asserts that the future construction of the residence on Lot 61, address 289 Majestic Ridge Road, immediately northwest of the subject property, would contribute to increased volumes of stormwater runoff, making the issue more significant. Otherwise, would be required to be constructed in absence of variance requested. So see attachment G, site plan with approved variance request, which depicts the proposed location of the single-family dwelling positioned as far away from that drainage area as possible, and reasonably practical, taking into consideration the topo of the property, the direction of stormwater runoff to the lower elevations of the property, while accommodating the proposed building footprint. Lastly, the applicant claims that the hardship is not a result of his actions, but solely due to the ordinance requirements. Again, that would put the home directly in line of the stormwater runoff running directly across the property, and also adjacent and sitting between the adjacent property at 46 Pisgah Ridge Trail, where there's existing stormwater infrastructure, riprap, et cetera. The applicant contends that the variance request is consistent with the spirit, purpose, and intent of the ordinance because it will allow the reasonable use of the property while maintaining the character of the surrounding neighborhood. Per the applicant's project narrative and supporting measurements, the adjacent residence, single-family dwelling at 46 Pisgah Ridge Trail is located approximately 35 feet from the front property line adjacent to Pisgah Ridge Trail. The approval of the 25-foot front yard setback variance would result in the home site location being similar to the property or the single-family dwelling at 46 Pisgah Ridge Trail, which the applicant argues would make a more consistent development pattern with the neighborhood. The applicant further states that constructing the residence in compliance with the required 60-foot front yard setback would place the front facade of the building in line with the rear yard swimming pool at the adjacent property located at 46 Pisgah Ridge Trail, which the applicant believes would be inconsistent with the neighborhood's established character. I do want to note that this evidentiary hearing was properly noticed. Public notice letters were mailed to adjacent property owners and the applicant on July 20th, and a public notice sign was posted on the subject property the same day. Legal advertisements ran in the Hendersonville Lightning on July 29th and August 5th. I would like to, staff would like to enter the following attachments into the record. Attachment A is a screenshot of the variance application submitted July 8th, 2026. Attachment B is the low-density residential zoning ordinance excerpt with the applicable codes, code references highlighted. Attachment C is a GIS aerial view of the subject property. Attachment D is a Google Maps aerial view of the subject property. Attachment E is the site plan for the proposed house without the approved variance request. Attachment F is a photo from stormwater discharge point from lot 61, taken on July 28th, 2026. Attachment G is the site plan for a proposed house with the approved variance request. Attachment H is the applicant's project narrative and justification. And then lastly, attachment I is their certificate of mailing public notice letters. With that, staff, I conclude my staff report.
All right, like to recognize the applicant if there's agreement or any objection to the exhibits as presented by the planning and zoning staff.
Mr. Ross, please come to the podium.
I agree though, yeah, those are.
You, no
Applicants.
objections, all right. Next, any questions for the planning and zoning staff from the board members?
No.
No? Recognition of the applicant to present evidence and testimony.
Well, Mr. Webb pretty much did it for us. I mean, we gave him all these attachments and information. He just pretty much summed it up almost better than I could myself. Just the most recent one is the new construction on that lot 61. It used to be the pipe was in the middle of the lot, which helped disperse the water. And since then, they've rerouted it more, so it's facing a lot of it more in a bigger discharge.
Yeah, they moved the pipe over about 30 feet now to discharging a 24-inch culvert now directly towards their lot, even more so. And then like what we were talking about, the neighbor, they also have a 24-inch culvert that discharges water down the side. So it may have even gotten worse over time.
All right, any other marks,
What was it?
questions to the applicant from the board?
No, do you have a picture of where 61 is as opposed to where your property is?
It
Or
is
not?
one of the exhibits. So if you look at exhibit F that's taken from our lot, looking over at lot 61.
So I'm standing in your lot
You're standing in my
theoretically?
lot, yes. And so that's the newest picture we have from their lot where they've shifted the stormwater drainage. It used to be right in the center of the lot there. And so like my photo said, they moved it 30 feet closer to our lot to discharge the water.
Around their property.
Right.
But your lot is on the back side of them to the right, correct?
If you're standing from our lot, they're diagonal kind to the left, yeah.
Do we have maybe a view of the
Of the whole
neighborhood so that,
I don't know if we have one that captures their lot in it.
Now I can address you and like show you something.
sure,
This is-
I can't say that, no,
No.
you may want to stand in front of us.
Yeah,
So that the whole
like to
board
have
can
it-
see it.
Yeah, visible to all members of the
There
board.
you go. Stand like this.
Okay.
All right,
Their lot sitting like this. This home is sitting right here. That's where that parcel is sitting. Okay, so instead of the water that used to discharge down the center, there's a home that is now placed in.
Would it be the system if the GIS where the pointed out.
Yeah,
Great.
that would be
Very
better.
comprehensive.
Mm-hmm. Yep. You do that?
That's the, before the new home site was developed. So that discharge, you can actually kind of see if you look at the grass where the water is running down through there and it is going towards the corner lot where it says Mills River. That is the lot discussion. So that water is currently, beforehand was running kind of right down the property line. Now that that discharge pipe has been relocated around that large foundation, it's even more so directed towards the Ross's residence. The other home, the home beside the property we're discussing.
On up
there.
here and point.
Okay, there you go.
Get me up to speed.
There you go. All right, the other lot that we have of issue is there's a discharge coming off of Pisgah Ridge right here. And that home, next one up here, yes, that home is elevated compared to the lot where we're going to be potentially building. So all this water discharge, you can see where the water has been running down the back of their property, which would be right in the middle of where their home is being placed at now currently. This water here is discharging down the back of it, so the whole back third to half of the property, when it has heavy rains, it has a substantial amount of water. It's all discharging from those roads. The other point from an aesthetic standpoint, a lot of this home that's neighbored here is exactly 50 feet from the curb. And with this variance request, that now puts their home up in line with the other home beside it. So it kind of has a little more cohesive appearance.
Did that answer your question?
Well, I
Any-
got you.
Yes.
The home to the north that's elevated above this lot, looks like it's got some sort of rock dissipator or something that's running parallel down that edge. It actually looks like it kind of encroaches on you. Are you getting water from there at that point too? Okay.
Yes.
So that's,
And again, it's one of those things he did that on a good faith, trying to put some riprap to
I
help.
get it.
And
I
so
get
it's
it.
one of those pick your battles. He tried to help. It may have made it a little worse,
Got it.
but he's a neighbor. And so that's another discussion.
I was just curious. Thank
Yeah,
you.
no, I appreciate that. And as you notice, that's where the pool is in the back of their yard. If we, adhere to the setbacks, their front door is almost in line with the back of that pool. Which I don't think either resident is a fan.
Okay, any other questions? Nope. Thank you. Is there any other person with standing that wants to be recognized to present evidence? None? Any other person wishing to present expert testimony or competent material and substantial evidence? None? Preliminary discussion from the board with input from any party or witness that we want to recognize. Any discussion?
Appears to be clear, hard evidence. There is a drainage issue.
All right. Any more?
What was that?
Clear, hard evidence through GIS, through the applicant's photos as presented in the evidence that there is a drainage issue on this site.
Actually,
Yeah,
disagree.
great
I think some evidence presented evidence. I think we take this testimony at face value that there is a drainage. unless we have evidence.
I think the application with pictures shows that there is a drainage.
I thought that's what I just said.
Well, I'm just repeating what you said.
Maybe I didn't understand what you just said.
We
I
agree.
don't think you did. That's exactly what I just said.
Any other discussion? Like to entertain a motion to close the evidence portion of the hearing then?
So
So
moved.
all in favor? Next is deliberation of the board. Any concerns? Then we would like to get a vote on the findings of facts that we have lined out for us.
I'll make a motion. I move that an unnecessary hardship result in strict application of the ordinance, because it would allow heavy rain runoff to go across building site.
That's your motion.
I second.
All in favor, say aye.
Aye.
We have to have 4 out of 5. We have all 5 in favor.
I'll also make a motion that the hardship results from conditions that are peculiar to the property, such as water runoff, such to water runoff through the middle of the property.
I second.
All in favor of that motion, say aye.
Aye.
Any opposed? 5 in favor.
I also make a motion that the hardship did not result from actions taken by the applicant or the property owner because it existed prior to.
Second.
All in favor, say aye.
I'd like to
Aye.
amend that motion. If you're echo of that, my amendment is the evidence presented by the applicant and the applicant's builder under sworn testimony that there was a movement of a stormwater pipe that exacerbated the flooding even further on that site. So it was existing and then was exacerbated by the moving of a pipe. Is that correct?
I agree to your friendly amendment.
All right.
I'll still
The
second.
amended motion, second,
I still second it.
all in favor?
Aye.
Any opposed? All in favor?
And I make a motion that the requested variance is consistent with the spirit, purpose, and intent of the ordinance. Such public safety is secured, substantial justice achieved, allows reasonable use of the property without the negative impacts.
I second.
All in favor of that motion?
Aye.
Any opposed? All 5 in favor? Then we need to get a motion on the variance with or without conditions. And we need a 4/5 majority to approve.
I make a motion that requested variance. I make a motion that we grant the requested variance because the board hardship standards were met. The evidence presented, I'm referring to variance request, VAR 6-04. Grant that against those restrictions of this board.
I second.
All in favor of that motion, say aye. Any opposed? Variance approved. And I would like to entertain a motion. Do we close this evidentiary hearing and we start a new one?
Yes.
Motion to close and during the current evidentiary hearing.
So moved.
Second.
All in favor?
Aye.
Thank you. Next is a variance application 2605. Request for a variance from section 154066L1, maximum non-residential building sized in mixed-use zoning districts. Like to entertain a motion to open the evidentiary hearing.
Motion to open the evidentiary hearing. Second.
All in favor, say aye.
Aye.
The announcement of the variance case, 2605, request for variance from section 154066, which I just read, maximum non-residential building size in mixed-use zoning district. I have read the quasi judicial procedure statement before. Obviously, that applies to this case also. Any of the board members' personal knowledge that they may rely on that is not in record?
Nope.
Recognition of any person wishing to petition the board to act as a party with standing. And those that have standing, please arise and so we can have our clerk swear them in.
Mr. Chair, I would like to ask that if people withstanding in the hearing are okay with Mr. Malchek attending remotely and participating. Is the applicant comfortable with that? Okay.
Thank you. Next, our planning and zoning staff will present the case and enter preliminary materials to the record.
Good evening. For you, you have a variance request, further known as variance 2605. Tonight, the Board of Adjustment will hear a request of Zach Cooper, Cooper Construction Company, appointed agent of the property owner, Northrop Holding 2 LLC, for the property identified as 0 Boylston Highway, further known for the PIN listed right after in your staff report. The request is for a 38,200 square foot variance from code reference 154.066 L1 of Town Zoning Code, which establishes a maximum non-residential building size of 15,000 square feet within the MR mixed use zoning district for non-residential buildings. If approved, the requested variance would allow non-residential development on the subject property to have a maximum building size up to 53,200 square feet. Zach Cooper with Cooper Construction Company submitted a complete paid variance application on July 9th, 2026. On July 20th, the application was amended to include the correct code reference for the variance under 154.066 L1. The applicant asserts the strict application of the 15,000 square foot maximum building size creates unnecessary hardship by limiting the project's economic feasibility and marketability for the proposed industrial park. Per the applicant, the proposed building size was determined based on commercial leasing experience and market forecasts, which indicates a demand for larger, flexible industrial spaces. The property owner intends to occupy one tenant space and lease the remaining units. The applicant further states that it is uncertain whether the future tenants will require a single suite or a multiple adjoining suites or units, and that the proposed larger building design provides the flexibility necessary to accommodate a range of tenant needs and size, space sizes. The applicant originally submitted a zoning permit application, zoning permit number Z24-250 on December 23rd, 2024, proposing 6 15,000 square foot industrial buildings for a total gross floor area of 90,000 square feet. The application was canceled on January 6, 2026, after the applicant failed to address staff's deficiency comments within the timeframe required by the zoning ordinance. The applicant subsequently submitted a new zoning permit application on May 26, 2026, and provided the revised site plan included in your report under attachment E. The revised proposal consists of two 39,900 square foot industrial buildings with the potential for 13,300 square foot building addition to building 2, as depicted on the site plan. Per the applicant, constructing 2 larger buildings instead of 6 15,000 square foot buildings would reduce building construction costs by $646,000. The applicant further states that the revised proposal includes a base gross floor area of 79,800 square feet, representing a reduction of 10,200 square feet compared to the original 90,000 square foot proposal, excluding the potential future building addition to building 2. Overall, the applicant estimates that the overall project would result in total cost savings ranging from approximately $593,000 to $698,600, depending on the final scope of the construction project. Applicant claims the hardship is unique to the subject property as there are 2 perennial streams located along the southern and eastern property lines. The applicant claims the entry and access roadway as well as sheet flow drainage diversion away from the eastern property line creek would result in spillage over the top of the proposed septic system and septic system area. Applicant claims the subsurface soil conditions indicate shallow, moist, and absorption rejective conditions, supported by a soil analysis in your staff report under attachment G. The revised site plan now shows a stormwater pond adjacent to the eastern property line creek, reducing sheet flow into Boylston Creek. Overall, the applicant claims the subsurface conditions related to smaller building footprints, reduced impervious surface area. They claim that the reduced impervious surface area reduces impact on the proposed septic system and drain field. The applicant claims the hardship is not the result of actions taken by the applicant or the property owner, but instead arises from a combined effects of the maximum non-residential building size limitation and the site's physical and regulatory constraints. Specifically, the applicant contends that compliance with watershed and stormwater management requirements, the property's poor soil conditions for development, market demands for industrial lease space collectively limit the ability to develop the property in a manner consistent with the owner's intended business model. The applicant contends the requested variance is consistent with the spirit, purpose, and intent of the ordinance because constructing 2 larger industrial buildings rather than 6 smaller industrial buildings will reduce the overall development footprint and the amount of supporting infrastructure required on the property. According to the applicant, the revised design preserves the site's rural character by concentrating development and allowing the buildings to blend more effectively with the natural setting. The applicant further states the proposed buildings will be designed to comply with the architectural standards of the town's corridor overlay district to create an attractive development that is cohesive with the surrounding area. This evidentiary hearing was properly noticed. Public notice letters were mailed to adjacent property owners and the applicant on July 21, 2026, and a public notice sign was posted on the subject property the same day. Legal advertisements ran in the Hendersonville Lightning on July 29th and August 5th, 2026. Now I'm going to enter the attachments into the record. Attachment A is the variance application submitted July 9th, 2026. Attachment B is the mixed-use zoning ordinance excerpt with the highlighted applicable code reference for maximum building size. Attachment C is the GIS aerial view of the subject property. Attachment D is Z24 zoning permit application Z24-250, the site plan with that application. Attachment E is the revised site plan dated June 1st, 26. Attachment F is letter from the applicant, Zach Cooper. Attachment G is a boring location plan, logs and lab work report from Gentry Geotechnical Engineering dated June 22nd, 23. And lastly, attachment H is the certificate of mailing public notice letters dated July 21, 26. And with that, that concludes staff's report.
Thank you. I'd like to recognize the applicant if they agree or object to any of the planning and zoning staff exhibits. Questions for planning and zoning staff from the board?
Have to. Well, what were the deficiency requirements that were not, met in their original application? That were not answered in a timely manner on the original application for the 6 building?
So I don't have those in the record. But the reason the application was canceled was lack of permit activity. So within the code,
Yes. All I need to know.
yes, sir.
Thank you,
Okay.
sir. Second question, the proposed addition, I'm assuming this is a site plan specific application. If this is approved, that proposed addition is a done deal without having to come back to the board or do anything. That's part of the application as well, correct? The addition as proposed to the, building number 2 or whatever, was that 11,000?
The building addition for
Potential
building, two, yes, sir.
Expansion,
Yes, sir.
okay.
So, the site, so the variance request being asked for tonight is for a maximum building footprint of 53,200 square feet. Now the board can make conditions reasonable, to the site plan, in relation to the variance. But if this was approved without conditions, the maximum building size not contingent to the site plan would be 53,200 square feet in total, if approved as requested without the board making conditions. And is that
That's
correct statement?
Yes, that's accurate. You can place any reasonable conditions related to the request on any variance applications made.
The 3,000 and change, that's the total amount of building that can be built.
Yes, ma'am. And that is for including the addition for building. Correct.
53,000
200 square feet. Yes, sir. 53,200
is
square
the
feet.
biggest building. That's building number 2.
Correct. But
No, because
maximum building size, so not building coverage on the entire lot, the total amount. So the maximum building size can be, if approved as is, can be up to 53,200 square feet.
it's the building number 2 with the expansion.
With the variance, yes.
Yeah.
So a site plan is required to be submitted with a variance application. So that is why the applicant is requesting 53,200 square feet to account for the maximum building size for that building too. But just to clarify that doesn't tie, if approved without conditions by the board, that is for any building size up to 53,200 square feet. So there can be conditions related to it specifically to the site plan if the board chooses to. But as is, if approved with no conditions, any building, non-residential building per that code reference for 15,000 square foot maximum building size could be built up to 53,200 square feet without a condition.
A building.
One building. There is no
the same.
code requirement for total coverage. Now, there are watershed impervious surface coverage limitations with low density and high density development that limits how much built upon area or impervious surface coverage you can have on the property. I will,
Attachment E says, if I read it right, building 1, building 2, and then total 79,800 square. Right, correct?
Me confused.
so that is the total development footprint. Before you tonight, you are looking at a variance request for the maximum building size for one building. So if approved as is, the development on that property would allow one building to be built up to 53,200 square feet unless conditions were imposed on the property by the board, at the board's discretion. So that is what we're looking at tonight.
That's depicted as proposed building two.
The variance is tied to the land. Yes.
What does that mean for building two? That's a little slow right now.
In terms of,
Says two buildings.
so that is the proposed site plan that will be associated with, that is associated with a active zoning permit application, further known as, I believe, Z26. I don't have the number exactly off the top of my head, but
Okay.
that is the revised site plan the applicant submitted with a new zoning permit application, because the previous one with the 15,000 square foot buildings as shown in attachment D was canceled due to lack of permit activity. The code allows, if staff comments aren't addressed within 6 months of being released to the applicant, staff can cancel the application due to lack of addressing those comments. So that's,
So I guess
Okay.
where I'm getting lost is the fact that the letter says, and then the picture shows that the base plan totals 79,800 square foot.
You're not the only one, Heidi.
So that's
So-
what I
I'm
understand.
getting older and
And
slower every
this-
day,
The
but I don't.
picture in attachment E shows two buildings.
correct. So that
Kevin,
is,
Could you just kind of, for the purposes of us that are old,
yes, sir.
I'm not following what's going on, because I'm not following it. So could you explain to me exactly what's being proposed here as far as, for Mr. Malachecki, the one? Because what I'm looking at is an application for two buildings, a considerable amount of impervious surface area that looks like it's going to be an area for truck turnarounds and whatnot. And an entry and exit from the property, as well as a stormwater pond in one fell swoop. Is that
Mr.
not
Burton, I
correct?
think the issue is that this is not an application for this specific plan. At this time,
That clears things up.
this is not an application for a specific plan. This is an application for you to give them permission to adjust the single provision for each building. Has to be no greater than 15,000 square feet.
Okay.
Ever how many they can fit on there.
Huh.
And what they're asking for is for permission to put at least one building of up to
53,200 square feet.
yes.
Yes.
So theoretically, should we approve it, does that mean that then if the property held it, they could build 6 buildings of that size? Is that
Yes,
what that
correct.
said?
Yeah.
Correct.
Thank you. That's what I need to know.
6 buildings of 53,000.
Correct.
If they can
If
fit
they
all the
can
rest
fit
of
it,
it.
no, I'm saying with
Yeah.
all things being equal. Or not equal. Okay.
Other questions for planning and zoning staff?
Maybe it's a silly question. Okay, someone with standing who is either here or wrote in, someone that has standing or has, I know it can only be true evidence, it's not opinions. Who are those people? Would that be people that we noticed because they live adjacent to the property?
It would be a person who is especially damaged by damage means somebody who is, at least case law out there. Special damage means special damage that is established through actual facts, expert witnesses, most usually of some specific damage they're going to obtain because of the request. So for instance, this is just for instance,
Yes.
if there was a expert real estate neighbor, a neighbor hired an expert real estate agent to come in, present certified expert, and you decided they were an expert. They said, we're guaranteed that this property will go down in value. That would be confident enough.
Okay.
Just simply somebody standing up and saying, yeah, my property's gonna go down, that would not be sufficient. That makes sense.
Yeah.
Just like if a traffic engineer might say, Wilson, I don't know how it happened, but Wilson Highway is gonna get busy. they, like I say, it's an impossibility. But if they've got a traffic engineer, came
Mhm.
and said, increase traffic because there's two large buildings instead of buildings of 15,000 square feet, that would give them special standards,
Okay.
special standard to, does that help you?
Yes, so if you had property around it that
Potentially could
could.
be outstanding,
could impact for whatever reason,
but
Okay.
you would have to bring in
experts of that matter.
experts and create a case that you agreed to, that you had special advantage.
Okay, thank you.
Mr. Keller. It wouldn't be the first time I'm the last guy in the room to get it. But I don't get it. I need a little bit more clarification. I don't see anywhere on the application a specific 53,200 square feet. I mean, I may have missed it, but I don't see it. I've not found that yet.
So, Mr. Burton,
Not unlike me to not found it.
so the 53,200 square feet,
Uh-huh.
the request for the maximum building size varying from the 15,000 square foot maximum building size for non-residential development, and mixed use zoning, accounts for the site plan shown, the 39,900 square foot building 2 plus potential expansion area. So in order for them to build under that site plan, they need the approval of the variance the variance would have to be approved. That's what we're trying to clarify.
But I think if you read the variance over and over again, it talks about 2 buildings. So that's where we're getting a little.
Yeah. And that's understandable because the variance does read is very confusing. But strictly speaking, what you're being asked to do is vary from the single requirement in the Mills River, in that zoning district, that buildings not exceed 15,000 square feet. That's what and anything else would be subject to your putting specific conditions
Okay.
as a condition of approving the variance. But strictly speaking, what you're being asked to do is vary from, to go away from the as written zoning, by making it, by agreeing that a building greater than 15,000 square feet can be built.
Okay, I'm gonna be lost here. I had really lost. So we're not approved a building per se. We're approving that so many square feet can be built tonight.
As one building.
As one building, correct. Mr. Malcheck, yeah, I hear you unmuted. Would you like to speak, sir?
Yeah,
Okay.
so can you hear me okay? Kevin?
Yep.
Yes, sir.
So this board considered, another building size variance case, I don't think too long ago. And so remember, although applicants can provide plans showing you what they're thinking of doing, this board's role tonight is just to consider, do you feel the hardships for 38,200 square feet of additional area on top of the 15,000 square foot max building size mixed use? It could be applied, if that approval runs with the land. So in theory, it could be used for 6 buildings. They could build 1 building that big. They may change their plans entirely and not even use that full amount and build buildings of varying sizes. But this board is just looking at, for this parcel, should the maximum building size change from 15,000 square feet to a total maximum of the 50,000 plus, which basically is just the variation, the variance request, plus the 15,000.
So the 15,000 is legal, is allowable.
Mhm.
So they're asking, right, so they want 38,000 more to be built,
They want-
not specifically as one unit. They could build a 20,000,
No, they're asking
Yeah.
in front of me, one building,
15,000
No, ma'am. No,
one building.
okay,
15,000 square feet, ordinance state, 15,000 square feet in any single building in this district.
Is what's allowable.
That's what's allowable by right.
Okay, by this piece.
They are asking for you to approve increasing, allowing them up to 50,000 plus in any single
One
building
building,
due to the hardships.
one building.
It can be as many buildings as
As
they
they
can
can
fit on there if you approve the variance.
It would
on that.
apply to every
So-
building they could put on
So,
there.
but we're applying, final totality is the 50,000 plus.
On
Per
one
building.
Per building,
building that they could.
per
yes.
building. The zoning regulation is 15,000 square foot per building. So on
Correct.
the exhibit, whatever it is, the original plan with the 6 buildings of 15,000 each, there was no requirement for a variance. Correct?
Correct.
So the 6 buildings of 15,000 square foot could be built without any interference from the Board of Adjustment because there is no need for a variance. They're asking for building a larger, more, 1 or 2 larger buildings with a maximum size of the 53, whatever,
In totality.
No,
No.
per building.
a building. They are asking to build 53,000 square feet in a building. If we approve it and they can squeeze 7 buildings on that property, all 7 buildings could be 53,000 square
Each
feet
building.
each.
Unless we
Unless
put a
we put a
limit in
limit
the
on it.
number of buildings we put on that
Correct.
property.
Unless the board agrees on putting a condition
Yeah.
on the variance approval.
That's
Correct.
Or that's the right wording.
Now we're good.
Okay,
Now we're good.
question for our planning board. Any questions here? Then next, I would like to recognize the applicant to present evidence and testimony. If you can come up to the microphone.
Good evening. I'm John May with Cooper Construction Company. The applicant was, application was applied, the name of Zach Cooper, and I've received.
Mr. Chair, I do apologize.
Sure.
Mr. Chair, you need to ask the applicant, if they agree to, or object to planning and zoning staff exhibits.
Any,
Did we do that? I thought he already.
objection?
Oh, I
think
I
asked
apologize.
that
Sorry,
one
sorry. I apologize.
Any other evidence or testimony that you want to give to?
I'd
the
like to
board?
make a few comments if that's acceptable.
Yes, sure.
Okay. Let me back up. The applicant's name was Zach Cooper. He's, senior vice president of the company. I've been appointed the representative by the owner to speak tonight. My name is John May, Cooper Construction Company. I'm vice president, and I'm the senior estimator for the company. Couple of comments that I'd like to make, not trying to interfere with the board discussion. But the owner, and due to the constrictions on the property, the owner is looking for a single building of 30. Well, I want to look at the statement to make sure. About 39,000 square feet, 39,900. So the base plan for the site is 39,900 square foot lots. The owner is asking for building number 2 to have in the future a possibility of another 300 or 13,200 square feet. That's the 53,000 square foot envelope that you're talking about. We have to apply for it now in order to get it approved and into the plans, or he can never, at least I don't believe he could ever ask for that variance again. Maybe he can. Not sure about that. So in essence, we're taking 15,000 square foot buildings, 90,000 square feet, and we're reducing the impact to the site, these two buildings. The two buildings were generated from market research that the owner employed with a real estate agent, and the market changed. The first application looked like the 15,000 square foot buildings was the way to go. Market research told them, no, folks want larger spaces. So the owner of the property is taking one space, and it gives him the flexibility to lease to a single tenant in a whole building, two tenants in a building, three tenants in it. So it's conceivable that you could have in building number one, the owner in one section of that building, and another business take the whole rest of the building. So the impact varies with traffic, number of employees, all those things come into play that he can't put his finger on today. So that's why we're asking for, market research shows that the large building is better. It's more flexible in space. It's been designed already through life safety with breakaway sections and all that. So we've done all our life safety studies. We've addressed the plan with required parking spaces based on what we're seeing. And another key point for me, the owner is sensitive to the vision from the roadway. It's highly elevated over the property. He's meeting all the requirements for the buffer along Boylston Highway, which is extensive. Both sides of the property have buffers. We have the right, I guess, to build a 40-foot tall building. We're somewhere between 26 and 28 feet high right now. So not only have we have an elevated road, we're sitting down in a hole, and we're not utilizing full height built. The roof slope from front to rear lessens even that impact. There's a facade on the front of the building that meets all the requirements of Millard River for textures and products. And with the singular turnaround truck area, we've limited loading docks and things of that nature. So we think we've lessened the impact of the overall site. It's plus or minus 15 acres. We're disturbing plus or minus 10 acres. So we're well under that. Her comments about stormwater. We have added a detention pond, which will contain the statutes for stormwater retention for our impervious area. So, excuse me. So we've already made that commitment to the project. We've had a traffic engineer not do a full study, but comment. When you come up out of the hole, if you will, they've requested a length of driveway. So the sight line left and right coming out on the Boylston Highway is protected. So we've done a lot of things to be proactive in the planning of the project already. With me is the Seaman Whiteside, who's a civil engineer. They've done all the studies for stormwater, roadways, impervious surface, ponds, the whole bit. So we're well down the road in the design phase, if you will. We are dealing with, as mentioned before, blue streams. So we've been sensitive to that with the detention pond and not influencing our runoff to that area. We do have a high water table at borings, boring number 3 especially. 4 and 6 influence the site, so that's why we pulled the building up close to the road. Try to improve those subsurface conditions. When the owner bought the property, there was no subsurface investigation. That was done after he purchased it and on behalf of the project. So I feel like we've done a lot to fit the area. I realize it's a commercial project. It's different. Try to be very sensitive to the whole area. Basically, my comments.
All right, thank you. Questions for the applicants from the board? Go ahead.
Thank you for that presentation. I'm understanding correctly, what y'all are in having the application is that the unnecessary hardship is limiting the project's economic feasibility and marketability. Is that correct? My questions are, if the property doesn't support what y'all are wanting to do, why aren't we finding a different property?
I can't speak for the owner, but he has purchased the property prior to engaging Cooper Construction in the pre-construction efforts. It's our job to provide him the information associated with the property. He did the boring on his own, provided those to us. We engaged Seaman Whiteside as a civil engineer to help determine the criteria of the property and what could and could not be built on it before we started down the path of design. Now, we have done design to give him a footprint of the two buildings. The 15,000 square foot buildings, in our opinion, financially creates a burden. It also impacts the site. It limits his ability to market a larger space to another time lease agent. They do light manufacturing.
But that's,
Heavy manufacturing in the buildings.
so that's in your opinion,
Which part?
that building the 6 buildings was not economical or what have you. You said that was your opinion.
It is substantiated by my estimates history. I'm a senior estimator for the county. I do all the pre-construction, OOM estimates. We engage trade partners to help us with current market pricing.
Mhm.
So, and I'm a nut and bolt counter. I don't square foot and say it ought to be this.
So maybe you can explain a little more as to why 6 buildings of 15,000 square feet are not as marketable as a 40.
Yes, she's asking, how did you determine?
I estimate, first estimate I did for them was the 15,000 square foot buildings.
Mhm.
Came up with a number with all the infrastructure, all the impervious surfaces, everything. So I give them an OOM, an order of magnitude estimate. It's X number of dollars. So then the owner goes and gets market research, and commercial lease space expert tells him that's not what you need to be building. You need to be building 2 buildings that have flexible space in them. I then turned around and did an estimate based on those 2 buildings with what we call an ad alternate to the 13,200 square feet on building number 2. So he has a total cost model from where he started to what it is with the 2 buildings.
So that's a cost model of his buildings, not of people wanting to rent the space.
He's basing this, his directive to Cooper Construction for the 2 buildings is based on his market research with a commercial lease agent.
Yeah, I must have misunderstood. I thought you said that was yours, that you did
I
that.
only provided the cost. I thought you were asking about the cost differential, why that was a hardship.
I was trying to figure out why we went away from 6 15,000 square
It
foot
was
buildings
really
to
the
one.
commercial lease agent
Hmm.
that directed him that way.
That's a government. How's your preference and the market forecast prediction a hardship? I'll ask it this, I'll give you an example. I may want to build a skyscraper up the hill in the residential area, and forecast may say it's a great place. You know, all predictors say this place needs to be, but the codes don't allow it. So how is that a hardship?
The hardship is purely John's opinion. It's the cost differential between 15,000 square foot buildings and 2 that are 39,900-ish. There is economy involved. There's economy in less roadway. There's economy in less disturbed area. Not sure I've answered it all, but
And my next question is, the ordinances that we have in the code do they not limit someone's economic feasibility anywhere? I mean, is that not what they do and by their nature is limit economic feasibility? As far as,
So that I could address that, I mean, you give me the opportunity to provide him 15,000 square foot building. It's a cost decision for the owner. That's just my opinion.
I agree. I hear you. And my last question is, and I know this is a little bit outside of your expertise, so this is more of an opinion by you. I mean, can we assume since the council approved these codes that they possibly, their intention was to limit feasibility of certain projects?
My opinion is the standard of 15,000 square foot buildings gives someone the opportunity of 90,000 square feet. Give or take. I feel like that the owner, through the market, and advisement from leasing agent, that he's making the right decision to get to these two buildings, if you will. You don't approve the 13,300 or 13,200 square foot, it's not a deal breaker. I mean, he's got something in mind for that. He wanted that added in for this application, in case he ever does it. But back to your question, should he have known that he could build 50,000 square foot buildings for so much money and apply and meet the requirements of the ordinance? Yes. And that was the direction he went in the beginning. I provided him the cost. Again, the lease agent directed to the owner says, this doesn't support the kind of market Mills River that district will sustain.
So.
Those
did
are my
you-
questions.
Were you the one, or were you on the original application for the 6 buildings?
Zach Cooper has always been the applicant.
Okay,
Truth of the matter is, the letter that's in front of you, I wrote. Zach Cooper reviewed it, approved it, it went through all the channels in our company, and his signature is put on it.
thanks.
Actually wrote what you're reading on the Cooper letter. And application as well. And I conferred with Seaman Whiteside on the application. Some of the language comes from them as well.
Any other specific questions for you?
I have a couple from Mr. May, might be for your civil also. And I'm gonna have to kind of get around to this, how I get to this, the numbers that you're presenting. The cost savings that you're saying, is that taking into consideration site preparation? From what appears to be not the greatest, and as you mentioned, the applicant kind of bought a pig and poke here, it sounds like. And when he had Will Gentry's guys come out and do these borings, I think there was it appears to be a little bit of an uh-oh moment. So my question is, as far as the expenditures that are being claimed for the 2 buildings in terms of site prep, achieving Proctor, doing all the things that are necessary for those 2 large buildings versus 6 smaller buildings, how does that work as far as scale?
You're correct. Horizontal and vertical construction.
Okay.
Civil and obviously sticks and bricks. So it was all considered stormwater. 2 or 3 times, get it out of flood water, if you sheet flow it, all of it.
Thank you.
Any other questions?
Yes, I do. I have one more. You brought up the application, the creeks were brought up, as being peculiar to that property. I'm assuming those creeks don't stop, just at the borders of that property. So why is it peculiar to yours, not the other properties?
So, the creek to the left of the property, we have engineered pond conditions that are not influencing and directing everything into the storm retention pond. And by moving the buildings forward and impervious surface, we've got much more area of sheet flow for this creek in the back. We think that we've done the right thing to try to preserve those creeks, not influence the flood.
You explain what sheet flow is.
Yes, so if you take the whole site of impervious, which is the building, pavement, whatever's going on within that, I told you we were disturbing 10 acres. Not all of that is impervious. How much impervious, you know? Maybe around 7 acres. We're influencing less than half the 15 acres. So the sheet flow is whatever we generate under this umbrella of building square footage, impervious surface. So every how many gallons is coming off of that, that we don't direct on sheet flow. So it runs down the slope of the back block. Do you have any idea gallons about the plans here?
Nothing, not in gallons, cubic feet per second, based on preliminary calcs with the stormwater plan. We're taking water from the site as well as off-site. And the in condition in the 2, 10, 25 and 100-year storms, we are reducing the net cubic feet per second runoff volume towards closer.
One more quick, I just not seeing it on anything. Is this property in the water supply, water protection area? Is this property in the water supply, water protection? So as to light industry, you're gonna be having a well, that's the plan you say?
Yes, sir.
So, you know, the availability of processed water I'm assuming your septic is gonna be able to take interesting things in the sewer system other than.
Yes, so
Let's
Can you
keep
speak on that,
the
Lou?
questions really to the variance for the size of the building. So want to make sure.
let me go real quick. Back in. So currently, there is no processed water from light manufacturing.
Mhm.
If a tenant has that requirement, it'll all be harnessed. Retained pump, sump, or whatever has to happen with that. So, septic is an interesting topic because we don't know how many tenants we have, right? So we have, our architect has calculated 8 individual units with the required restrooms. Total people using it and produced a septic water discharge gallons per minute. We have had a septic engineer look at that, and he has made a preliminary decision on what size the septic needs to be.
Okay, but that has nothing to do with the size of the building. So
Sure it
I
does.
want
It
to,
does.
it
Bigger
does
buildings
not,
have an
because
opportunity.
you have the potential to put up the 6 buildings of 15,000 square foot each
Yes.
without any variance.
That's correct.
So I want to make sure that we keep focused on the actual variance for the number of square foot per building and not get sidetracked on sewer or water, which has nothing to do with the variance. Any other questions?
Well, yeah, no, I do. And he did, in their evidence, they are talking about watershed and so.
Mm.
Oh, yeah.
Evidence they're presenting.
Yeah.
Um,
There's an argument that they try to use for getting the potential of bigger buildings, but I want to focus on the variance, which is allowing a bigger building.
trying to do that. I do have a question. On question 3, I'll put the hardship is twofold. First, the building structure as described, extensive civil investigation has revealed the combination of watershed, soil conditions, changing lease market. It's talking about the issues with the watershed and the soil conditions. Was that for the original plan of the 6 buildings?
It is, but it would affect it differently. Yes.
Like, I guess you're getting to my point. If it can't support 6 individual buildings at 15,000 square feet, why can't it support 2 at 39 or 1?
Yeah, it will support 6,000 square foot building. The beauty of what, I shouldn't say the beauty, the feature of what we're trying to propose here with 2 buildings is that we are able to capture stormwater, pipe it to a retention pond, Whereas 6 buildings, we can sheet flow those and try to catch it down before it hits the stream. At least the turtle. Whatever we can do to make 6 of them work. Septic comes into play pretty strongly. In that those 6 buildings, would have to be tied together and a central system taken to a larger septic field. Or you put in 6 septic systems, I mean. You have to understand, we're at a 30,000 foot level. He doesn't know what lease agreements he would have. We don't know the number of tenants. We plan for worst case scenario. The civil engineering supports what you have in front of you. No doubt in my mind, we're gonna handle stormwater. We're gonna meet everything that Raleigh's gonna tell us. I think we've made a great effort in pre-construction to address all the things that we've had as potential issues.
What y'all are proposing, if I'm hearing you correctly, would actually help the control of the water flow into Bolston Creek.
Yeah,
If we're taking to a storm drain or a storm pond, not
Yeah.
all.
Yeah, the biggest thing with the smaller building footprint, you're encompassing a larger area. So with these larger buildings, you can consolidate where you're actually sending water. So that's the biggest thing.
I want to touch on that because y'all listed it. The reason I was touching on that.
Other questions? All right, thank you.
Thank you all for your time.
I'd like to recognize any person with standing that wants to present evidence or give testimony. If none, then I would like to get to the preliminary discussion of the board with input from any party or witness. These multiple. So the question for the variance, again, is the maximum size of
Any building,
any building on that property.
correct?
The 6 buildings of 15,000 could be put on there without our control at all. So that's 90,000 square feet.
Yeah, so the issue I'm having is, I like the fact that we're then we're getting into the fact that there's sure that the folks that if we don't approve this variance, they'll find a way that they can adequately control. I don't know that the water flow should be a determining factor. Though I do recognize it. The issue, one of the issues I'm having.
Yeah.
Is that basing the hardship strictly on, large part on the feasibility, market studies and stuff like that. It seems like it is a fluctuating scale, economic determinations that our council, when they passed these ordinances, I mean, they chose these sizes limitations. And I can't get, and I feel that when the council passed it, necessary, they were necessary, the body felt it was necessary. So it's not an actual property issue for me. It's somebody who has looked at the data and said, we are now going to call this a hardship. We can apply that in, just like my example with
Okay,
high rise.
the only argument there I have is they could put up 90,000 square feet of buildings at 15,000 square foot each building without a problem.
I don't disagree with you.
Correct.
Then why do we have the ordinance? I mean,
The ordinance
guess
doesn't limit the
Well, I think
number of
visually
buildings
though,
per.
But 15,000 square foot buildings look much less massive than a 50,000 square foot
That's a.
building.
Like I said, I get back to my issue, the example in the residential area. I gave. If I have a feasibility study, says, hey, put it up there. it's a residential area that doesn't want skyscraper. Ordinances don't allow it. I can use feasibility and market value as shit anytime I want to. I don't think that's a legitimate hardship.
Agreed.
He's not really reducing the amount of square footage he wants to build anyway, much. Think about it. It's just what he wants to, I don't see the rationale, let's put it that way, for a financial hardship to go from 6 of these babies to 2 working it in. And I'm concerned about water. I think it's lovely and I'm not an educated water person. But I just think of all that water that's gonna, he kept saying Boylston Creek, and I know where Boylston Creek goes. And it can be, too, but that's not our problem.
I agree that his study, probably correct, that 2 buildings are probably better than 6 smaller ones.
Their square footage.
But again, I've,
But
you
you
know, in
have
this scenario, council found it necessary to limit that. And I think just based on market basis, shouldn't change.
What study?
There's no study about the water. I didn't see a study that talked about the water.
No, it's just square footage.
Right,
Yeah.
that's what I'm saying.
Well,
Right.
more
Get it.
square
I
footage
don't
is more
see-
water.
I don't even see any newer information in here. All the geographic stuff was from 2023, when 2024 is when the 6 buildings was submitted.
That's why I said we couldn't use,
So-
we couldn't use the water as a factor here
But
because it'd be guessing.
That information perhaps would have whatever, but it's not there.
Any more discussion, preliminary discussion, whereby we can get input from parties that we want to consider necessary at this time? And I would like to entertain a motion to close the evidence portion of the hearing.
Motion to close the evidentiary portion of the meeting.
Favor say
Aye.
aye. Any opposed? Deliberation of the board. Considering all of the factors set out in the ordinance. Finding of fact. I'm asking for input, discussion, so we can move on and get to the next case.
So. Um. Y'all can talk for a second.
Talk amongst yourselves.
We can put conditions on a variance. We can limit number of buildings, we can do all sorts of conditions, but the question is, do we want to give a variance on the 15,000 square foot up to whatever number it's in the application, but up to the number that is requested?
Technically, strictly speaking, Mr. Chairman, first question is there an unnecessary hardship? That's the first question that has to be answered. And, well, simply go down through the findings. of fact
Yeah.
Before you even get to the discussion of.
Mm-hmm.
All right, I have a motion.
Yep, go ahead.
I make a motion that unnecessary hardships would not result from strict application of the ordinance because using a changing and fluctuating market forecasting model that is what we don't have present here to consider is that, Mr. Upson. Not a sound reason. There is not a hardship. Can be considered, and also, I believe it was the intent to actually regulate that. That is not a hardship either. So I feel that the ordinances are necessary. and not a, it's a necessary restriction. But imposed, it's not a hardship.
Second.
If I need to kind of try to rephrase that.
Second,
Second.
all in favor of that motion? Aye.
Aye.
I got a hard time with it. But I will vote against that because I think that there are possibly conditions, but that's here or there. Your motion passes with 4 out of 5.
Do we need to continue with the others? Since it's been-
Yeah.
You need to, continue with. the-
Standard 2.
Yeah, and it, not that it matters whether they're found not at this point, but you need to continue with it.
Okay.
I make a motion that a hardship does not result from conditions that are peculiar to the property, such as location, size, and topography caused the creeks that's referenced in the application also affect other properties.
I second.
All in favor, say aye.
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 That motion passes.
I'm having trouble making 3 because they haven't taken action yet, but done anything. So,
As I said,
and I find there's no hardship, so it's hard for me to say that a motion that a hardship exists when I don't feel like a hardship exists. So I guess I make a motion that a hardship did.
you make a motion to find as the fact that no hardship exists. It doesn't matter.
I make a motion that no hardship exists. Sure.
Second.
All in favor?
Aye.
Aye.
Passes.
I feel, make a motion that the requested variance is not consistent with the spirit, purpose, intent of the ordinance. Such as public safety is secured and substantial justice achieved because first of all, based on the models that I already referenced, and it is inconsistent with what the council has determined is necessary.
Second.
All in favor, say aye.
Aye.
Right, vote on the variance,
Make a motion that we deny variance
2605. I second.
6-0.
Yeah.
Did not meet the hardship standards.
second,
I second.
all in favor?
Aye.
Variance denied. Like a motion to close and adjourn this evidentiary hearing,
Motion to close this evidentiary hearing.
all in favor?
Aye.
You, next. Variance application 2606, a variance from section 154-058 C8 side yard setback for principal structures and section 154-112 and B for accessory structures and buildings, side yard setback and rear yard setback for accessory structures in the neighborhood commercial zoning district. Motion to open the evidentiary hearing.
Motion to open the evidentiary.
All in favor?
Aye.
Announcement of the variance case 2606, which I just read. The quasi judicial procedure statement, everybody has heard before, that applies to this variance application also. Any of the board members' personal knowledge of, on this case?
Nope.
Recognition of any person wishing to petition the board to act as party with standing. Swearing in of those present to present evidence. the applicants and our zoning administrator.
Mr. Chair, I'd like to, confirm that it's okay for Mr. Malcheck to participate remotely in this hearing. Does the applicant?
Agrees to that?
Thank you.
You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
All right, recognition of the planning and zoning staff to present the case and enter preliminary materials into the record.
Thank you, Mr. Chair. For this hearing, the Board of Adjustment will hear a request of Jared Van Wingerden, property owner of 140 Blackberry Lane, further known in the Windover Woods subdivision. The application requests the 20-foot variance from 154.058 C8 of the town zoning code, which requires a 30-foot side yard setback for principal structures within the neighborhood commercial zoning district. If approved, the variance would reduce the required side yard setback for the principal structure to 10 feet as measured from the side property lines. The application also requests a 5-foot variance from code reference 154.112A and a 20-foot variance from 154.112B, which establishes the required 10-foot rear yard setback and 30-foot side yard setback for accessory structures and buildings within the neighborhood commercial zoning district. If approved, this variance would reduce the required rear yard setback for the proposed accessory structure to 5 feet as measured from the rear property line, and the required side yard setback for the proposed accessory structure to 10 feet as measured from the side property lines. On July 10th, Mr. Van Wingerden, the property owner, submitted a complete and paid variance application to Town Hall. The applicant claims the strict application of the 30-foot side yard setback requirement for principal and accessory structures, including the 10-foot rear yard setback requirement for accessory structures within the property zoning district, creates unnecessary hardship. Per the applicant, the hardship results from the property's legal non-conforming lot size of 0.39 acres, which is 0.3 acres smaller than the minimum lot size currently required for single-family dwellings in the neighborhood commercial zoning district. 30,000 square feet or 0.69 acres. The applicant contends the reduced lot size significantly limits the available buildable area, leaving little room to construct building additions to their home or construct accessory structures on their property that require with the setback standards. The applicant further notes that the rear property line is the narrowest within the subdivision, measuring 91 feet, as shown on the Henderson County GIS aerial image in attachment D, compared to most of the other properties within the subdivision with rear property lines of a roughly 125 feet. In attachment E, the applicant states the proposed 20 by 18 screen porch, as shown on the site plan, requires a setback reduction from the 30-foot side yard setback. The site plan shows the screen porch located approximately 14 feet from the side property line, resulting in a setback of 16 feet. However, the applicant is requesting a 20-foot side yard setback reduction to allow an additional 4 feet of flexibility if minor site plan modifications become necessary during construction. The applicant also proposes to construct a 28 by 20 deck with a 4x4 staircase extending towards the rear of the property. According to the applicant, the proposed deck requires a 5-foot reduction from the 10-foot rear yard setback applicable to accessory structures. As proposed, the deck would be located 5 feet from the rear property line and 27 feet from the side property line, with adjoining property at 164 Blackberry Lane. The applicant claims the hardship is unique to the subject property due to the Department of Environmental Health well and septic setback requirements. Per the applicant, the existing drain field is located in the center of the rear yard and the required 5-foot setback from the septic system for permanent structures substantially limits the usable area available for property improvements. The applicant states also that the required 50-foot setback from existing well located on adjoining property, further known as 164 Blackberry Lane, extends onto the subject property, further reducing the buildable area available for proposed improvements. The applicant claims the hardship is not the result of actions taken by themselves. According to the applicant, the subject property is legal nonconforming and was platted before the Townsend Corporation, and the adoption of the current minimum residential lot size, 0.69 acres, 30,000 square feet within the neighborhood commercial zoning district. The applicant claims that the variance request is consistent with the spirit, purpose, and intent of the ordinance. Because the property and surrounding properties are zoned neighborhood commercial and are developed primarily with single-family residential dwellings. And per the applicant, the building addition and accessory structure are common residential site improvements that will not alter the residential character or the aesthetics of the neighborhood. Lastly, the applicant further asserts that approval of this variance request will allow the proposed improvements to be located outside the required Department of Environmental Health setbacks associated with the septic system and the well setbacks from the adjacent property located at 164 Blackberry Lane. This evidentiary hearing was properly noticed. Public notice letters were mailed to adjacent property owners and the applicant on July 20, 2026, and a public notice sign was posted on the subject property the same day. Legal advertisements ran in Hendersonville Lightning on July 29th and August 5th. Staff would like to enter the following attachments into the record. Attachment A is a screenshot of the variance application submitted July 10th, online 2026. Attachment B is the neighborhood commercial zoning ordinance excerpt with the applicable code references, sections highlighted. Attachment C is the code references for accessory structures and buildings. Attachment D is a GIS aerial view of subject property. Attachment E is the site plan for the variance application. Attachment F is a Henderson County Department of Public Health permit. I believe it's a subject permit, if I'm correct. I can confirm that. Yes. Attachment G is the project justification and narrative. And then lastly, attachment H is a certificate of mailing for the public notice letters, July 20th, 2026. And with that, that concludes staff's report.
Thank you. Recognition of the applicant to agree or object to the exhibits that were just presented. Thank you. Questions from the board to the planning and zoning staff? Any? Nope. Okay. Recognition of the applicant to prevent evidence and testimony. Please come up to the microphone.
I hope this is less complicated than the last one, but the first thing is I don't really know what to say. I'm gonna be better at answering questions. I'll just say that my wife is from Florida. I'm from Illinois. We've had no views our whole life. So when we moved here, we wanted to make sure that we never blocked the neighbor's view or our view. We got horses out in the distance. So we built like a see-through iron fence. And currently we have a trampoline with the safety net surrounding it. And it's kind of an eyesore. It's like between us and the horses. So I grew up in Illinois with a trampoline with a deck surrounding it at the same height of it. So if you ever fell off, you're falling onto a deck that's the same height as, it's not a 4-foot drop into the ground. So it was like relatively safe. You didn't need a net. And we want to build that. That's what the rear structure would be. And I think the best way to kind of see what we're dealing with here is attachment E, where I kind of drew out where the septic leach field is, where the neighbor's well is, and our existing house and existing deck. And we really don't have anywhere to build that wouldn't require a variance. So we tried to choose the most conforming locations for anything that we did. So like the screened-in porch is just enough clearance to not interfere with the neighbor's well. It's also just enough clearance not to be too close to the leach field or the septic tank. And as far as the trampoline is concerned, at the rear of the deck, the rear deck structure, it's a 10 by 17 trampoline, so that basically gives a 5-foot radius around trampoline, so there's enough distance for anyone to get on and off without any trouble. So that's basically. the
Thank
gist
you.
of it.
Questions for the applicant at this time by the board?
I don't have it.
Heidi?
Nope.
Nope. Any person withstanding to present evidence or testimony? No. Preliminary discussion. By the board, and you can ask for input from any party.
I don't have any.
I do not.
No? I'd like to entertain a motion to close the evidence portion of the hearing.
Second.
All in favor, aye?
Aye.
Aye.
Thank you. Deliberation of the board, consider all the factors set out in the ordinance.
Have a motion when you're clear. I make a motion that unnecessary hardship would result from the strict application of the ordinance because of the legal non-conforming lot size that limits the available building area.
Second.
All in favor?
Aye.
Any opposed? Passes with 5 votes.
I make a motion that the hardship results from conditions that are peculiar to the property, which are the legal non-conforming, which is the legal non lot size.
I second.
All in favor?
Aye.
Any opposed? Passes with 5 votes.
I make a motion that the hardship did not result from the actions taken by the applicant or the property owner because the lot size was created before the incorporation.
Second.
All in favor?
Aye.
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 Any opposed? Passes with 5 votes.
Make a motion that the requested variance is consistent with the spirit, purpose, and intent of the ordinance such that public safety is secured and substantial justice is achieved by allowing the reasonable use of property allotted for incorporation.
I second.
All in favor? Any opposed? Passes with 5 votes.
I make a motion to grant the requested variance because the 4 hardship standards were met based on the evidence presented, and that is variance number 2606.
Second.
All in favor?
Aye.
Variance passes.
What's the correct variance?
Yes,
Yeah.
it was.
Yeah.
I got you.
Thank you. Motion to close and adjourn this evidentiary hearing.
Second.
All in favor?
Aye.
Next, variance, a motion to open the evidentiary hearing. All in
Make
favor?
a motion,
Yeah,
open
all
the
right.
evidentiary.
Open it. Announcement of variance application, 2607 variance from section 154.047 D6 and 8 front yard setback and side yard setback in the low density residential MR30 zoning district. The quasi judicial procedure statement I have read before. Any board members' personal knowledge?
None.
No. Any person wishing to petition the board, to act as a party withstanding? swearing in those to present evidence, the applicant and our.
Mr. Chair, if it's okay with the parties, participating in the hearing, is it okay for Mr. Malachek to participate remotely? Okay, thank you.
Yep. You, recognition of planning zoning staff to present the case and enter preliminary materials in the record.
Thank you. Before you, tonight, the Board of Adjustment, will hear a variance request from Michael Sakin, property owner of 0 Soapstone Trail, further known as PIN 964-118-9588, located in the Farm at Mills River Residential Subdivision. The application requests a 37.5-foot variance from code reference 154.047 D6, the 60-foot front yard building setback, and 15-foot variance from 154.047 D8, the 30-foot side yard setback requirement, within the low-density residential zoning district. If approved, the variance would reduce the front yard setback for the property from 60 feet to 22.5 feet and the side yard setback to 15 feet. Michael Sakin, the property owner, submitted a complete paid variance application on July 12, 2026. The applicant claims the strict application of the 60-foot front yard setback and 30-foot side yard setback requirements for the district create an unnecessary hardship due to the unique characteristics of the property. According to the applicant, the lot has 4 separate front property lines that affront a T turnaround for the Soapstone Trail right away. As a result, there are 4 front yard setbacks that substantially reduce the amount of buildable area on the property. The applicant further states that a MSD Metropolitan Sewers District sewer easement transverses the rear northern portion of the property. And in addition, there is a 30-foot perennial stream buffer that extends along the rear portion of the property located along the northern property line. The applicant notes the rear northern and western portions of the property also contain steep slopes ranging from 25% to 60%, again, further limiting suitable building location. See attachment E for references. The applicant claims the combination of these site constraints leaves a limited and irregular building area that cannot reasonably accommodate a single-family residence without construction on steep slopes, resulting in substantial grading and foundation challenges. Again, the applicant further asserts that these constraints significantly limit the available of functional outdoor living space for customary residential activities, including family recreation and children's play. The applicant maintains that the strict application of the required setback standards creates unnecessary hardship by preventing reasonable use of the property. The applicant claims the hardship is unique to the subject property and is not generally shared by neighboring properties. Unlike most lots within the subdivision, Lot 69 has 4 separate front yard setbacks that front on a T turnaround on Soapstone Trail that create 4 separate front property lines that the 60-foot front yard setback is applied to. Sorry, I lost my. The applicant further states that the property is constrained, again, by a MSD sanitary sewer easement, adjoining perennial stream along the northern rear property line, steep topography affecting portions of the rear lot, and asserts that all these site-specific characteristics create a substantially smaller and irregular building area than typical surrounding residential lots. Applicant claims the hardship is not the results of any action taken by the applicant or property owner, as the site conditions existed prior to the acquisition of the property. The T turnaround street configuration, the recorded sanitary sewer easement, the 30-foot perennial stream buffer, as mentioned, along the northern rear property line, and the steep topo affecting the rear western portion of the line are all pre-existing conditions beyond the applicant's control. The applicant asserts that there were no alterations to the site that would have contributed to the hardship by the applicant. Lastly, or not lastly, the applicant claims the requested variance is consistent with the spirit, purpose, and intent of the ordinance because it represents the minimum deviation necessary from a strict application of the ordinance to allow for reasonable use of the property while preserving the intent of the low-density residential zoning district. Per the applicant, the site does not seek to encroach into the perennial stream buffer, into the sanitary sewer easement. Instead, it would allow the proposed residents to be located within the most suitable building area while preserving usable rear yard space, minimizing disturbance to steep slopes, and reducing the need for extensive grading. The applicant claims that granting the requested variance will preserve the residential character of the neighborhood, maintain the orientation of the single-family dwelling consistent with surrounding homes within the subdivision, and allow for reasonable use and development on a uniquely constrained property. The request will also provide, as mentioned previously, functional outdoor living space consistent with the intended residential use of the property. The evidentiary hearing was properly noticed. Public notice letters were mailed to adjacent property owners and the applicant on July 20, 2026. Public notice sign was posted the same day. Legal advertisements ran in the Hendersonville Lightning on July 29 and August 5th. Staff would like to enter the following attachments into the record. Attachment A is a screenshot of the variance application submitted July 12th. Attachment B is the low-density residential zoning ordinance excerpt with applicable sections highlighted. Attachment C is a GIS aerial view of the subject property. Attachment D is a subdivision plat for the farm at Mills River Phase 2, approved December 1st, 2022. Attachment E is a marked up plat of Lot 69 depicting site constraints. Attachment F is a Henderson County GIS slope report. Attachment G is a site plan for the property owner dated July 2nd, 2026 with 1-foot contour intervals. Attachment H is the application site plan depicting each requested front yard setback variance separately and also the side yard setback. Attachment I is the project narrative and justification. And lastly, attachment J is a certificate of mailing, public notice letters dated July 20, 2026. With that, that concludes staff's report.
Thank you. I'd like to recognize or get the recognition from the applicant to agree or object to the planning zoning staff exhibits. Thank you. Questions from the board to the planning and zoning staff?
I have none.
All right. Recognition of the applicant to present evidence and testimony. You can come to the microphone.
Good evening, everybody. Yeah, it's late. Thank you so much for your time today. So my name is Mike. It's Mikhail, but I go by Mike. I own lot 69. I closed on it right after Helene. So I've owned about for 2 years, and for the past few months, we've been trying to figure out how to fit the house on the lot. It's a very unique lot in the subdivision, as mentioned by the board and by Mr. Kevin there. There's a T intersection, and it introduces technically 4 separate front yard setbacks, which was kind of news to me. I didn't realize that's how things work. And then upon further investigation, I realized that I'm dealing with a lot of front yard setbacks. And then I have the slope on the side and then the sewer on the other side. So it was kind of difficult to fit the house. Technically, it's, you know, it's one reduction because it falls under one section, but I kind of broke it down to different lines. L 15, 16, 17, 18, if you look at, I think, attachment I. And I also drew 4 different sections to show you. Basically, the house is an L shape. That's kind of only really the floor plan that would work there. There's also restrictions on the size and style of a home and, you know, a few other things by the architectural board at the farm. And technically, most of the house, the important setback for me, it's within a 60-foot. Actually, the house sitting further back from where I originally thought the setbacks were. But the 2 other setbacks, due to the intersection or the T turnaround, kind of brought in some hardships. We really couldn't fit the house anywhere else. If we push it, you know, for the one way, we hit the sewer. If we go the other way, we have a big slope right behind the house. On the other side, obviously, there's a road and there's a neighbor on the other side. So I'm kind of constricting on these things. So, but I love taking your questions. I don't know if it's confusing.
No, no. Thank you for that.
Yeah.
Questions? Thank you.
Yeah.
Questions to the applicants by both?
Your HOA going to be okay with the reduced setback?
Yeah, I called the HOA owner and they said they were gonna go by the Town Mills River decision.
Other questions?
Nope.
Thank you. Any other person withstanding to present evidence or testimony? If none. Preliminary discussion with input from any party or witness that. None?
No.
That's a short discussion.
Yep.
I'd like to entertain a motion to close the evidence portion of the hearing.
Second.
All in favor?
Aye.
Thank you. Next, deliberation of the board, considering all the factors set out in the ordinance.
Like you to do. Next slide.
See you guys.
I make a motion that unnecessary hardship would not result from the application of the ordinance because of the unique.
So, Greg Gardner,
I'm on the
did I
wrong one.
understand you correctly? Did you say hardship would not
No.
result?
Would.
Would result.
I got carried away.
I'm just checking.
That's why you get the big bucks. Make the necessary hardship would result from the strict application of the ordinance because of the uniqueness and topography of the lot.
A second.
All in favor?
Aye.
Aye.
Any opposed? Passes with 5 votes.
Make a motion that the hardship results from conditions that are particular to the property such that it has 4 front
Yep.
yards.
Okay,
Is that enough? That-
Ms.
And a big sewer line and other,
Cole, are you referencing front yard setbacks?
yes, front yard setbacks.
Okay.
Or different front yard setback.
Second.
Patty, you got it?
Pretty liked it.
All right.
Loved it.
Second, all in favor?
Aye.
Any opposed? Passes with 5 votes.
I make the motion that hardship did not result from actions taken by the applicant or property owner because the lot was such in existence at the time that he purchased the lot.
I second.
All in favor?
Aye.
Any opposed? Passes with 5 votes.
I make the motion that the requested variance is consistent with the spirit, purpose, and intent of the ordinance. Such that public safety is secured and substantial justice is achieved because the owner is respecting the constraints put upon him and still trying to build a proper home.
Second.
All in favor?
Aye.
Any opposed? Passes with 5 votes.
Seven. I make a motion that we approve the variance for variance 26-07.
All in favor?
Aye.
Any opposed? Variance passed.
For the record, I'm sorry I was calling that attachment I. I've got it.
Yeah, that's it.
Yeah,
It's-
It was a one in my
One.
brain for a minute. before
That's
that
okay.
attachment
That's
I.
It's like, what are you
Um,
talking about? But okay.
Motion to close and adjourn this evidentiary hearing.
Motion to close and join this evidentiary hearing.
Second, all in favor?
Aye.
Thank you. Approved.
Yep.
Another motion to open the next and last evidentiary hearing.
Motion to open the next and last evidentiary hearing.
Anybody? All in favor?
Aye.
Aye.
Next. Announcement of the variance case, 2608, a variance from section 154-258 D1, maximum wall signage surface area in the Mills River zoning code. I've read the quasi judicial procedure statement before. This applies to this variance process also. Any board members, personal knowledge beside that you drive by and see it?
Yeah,
And in the end, that I believe it's where hopes and dreams are created.
I shop there often.
Any, let's see, recognition of any person wishing to petition the board to act with the party of standing beside the applicants? None. Swearing in those to present evidence.
Mr. Chair, I'd like to ask that, is it okay with parties of standing if Mr. Malcheck attends this hearing remotely?
Okay, next, recognition of the planning and zoning staff to present the case and enter preliminary materials in the record.
Thank you, Mr. Chair. The Board of Adjustment will hear a request submitted by Eric Young, appointed agent for the property owner Ingalls Market, concerning the property located at 3340 Boylston Highway. The property is located within the Mills River Plaza Shopping Center and is occupied by the business tenant Young Ace Hardware of Mills River. The application requests a 15.19 square foot variance from section 154.258 D1 of the town zoning code, which limits wall signage in the general business zoning district to 10% of the wall surface area, up to a maximum of 150 square feet. If approved, the variance would allow up to 165.19 square feet of wall signage on the building unit facade for the Ace Hardware. On May 14th, 2026, Matt Aho, Sign Systems Inc. submitted a permanent sign permit application, further known as Z2682, to install an additional 31.27 square foot of wall signage on the facade of the building unit occupied by Young Ace Hardware of Mills River. During staff review, it was determined the proposed increase in sign copy area would result in a total wall signage area of 165.19 square feet for the building unit facade, exceeding the maximum permitted wall signage allowance of 150 square feet per building unit wall. Staff notified the applicant the proposed additional sign area could potentially be permitted without the need for a variance upon the adoption of the town's proposed Unified Development Ordinance, which included increased wall signage area allowances for shopping centers. And on June 11th, 2026, Town Council adopted the UDO. However, on July 2nd, 2026, Session Law 2026-26 was ratified and became effective, rendering the adoption of the UDO null and void. As a result, the proposed increase in wall signage area could no longer be approved administratively under UDO standards. Consequently, the applicant elected to submit the variance application that's before you tonight to request additional signed copy area per 154.258 D1 of the town sign ordinance. Wall signage shall not exceed 10% of the total surface area of the wall to which sign or multiple signs is located, up to a maximum of 150 square feet. The maximum square footage requirement can be waived as part of a common signage plan. Of a common signage plan, if no signs on the building wall or building unit exceed 10% of the surface area wall requirement. The existing shopping center does not have a common signage plan and was constructed before the specific section of the sign ordinance or common signage plans was adopted on November 10th of 2017. Common signage plan is now required by town ordinance for all non-residential developments with multiple buildings or units that provide a uniform design and features, including different types of colors and dimensional requirements. On July 13th, 2026, Mr. Young, appointed agent for the property owner, submitted a complete paid variance application. He is the vice president of Young Ace Hardware, the current tenant at the subject property. The applicant claims the strict application of the ordinance would require the existing wall sign to be removed and replaced with a new sign featuring smaller lettering in order to comply with the maximum permitted sign area. Per the applicant, replacing the entire sign would impose a significant financial hardship on the business. The applicant asserts that a smaller sign would reduce visibility, making it difficult for existing and prospective customers to identify the business. Applicant claims the hardship is unique to the property because the shopping center building is substantially set back from Boylston Highway, further known as NC 280. According to the applicant, the tenant space occupied by Ace Hardware of Mills River is located more than 400 feet from Boylston Highway, necessitating larger wall signage to identify and brand the business for both passing motorists and existing customers. Additionally, since the Ingle Shopping Center was permitted before the town's current common signage regulations, it doesn't have the property or the business doesn't have ability to qualify for the common signage plan waiver, which would allow for the minor wall sign expansion. The applicant further claims the visibility of the storefront from Boylston Highway is diminished because of the Ingles gas station fuel canopy is located in front of it, blocking visibility of the storefront. So in addition, the applicant contends that a larger sign is necessary to ensure the business can be identified by motorists traveling Boylston Highway in a safe and effective manner. Applicant claims the hardship is not a result of the actions taken by themselves that would create this hardship. The applicant contends the variance is consistent with the spirit, purpose, and intent of the ordinance because approval of the request is consistent with the general business zoning district and wall signage regulations for general business. As the increase in signage is not a large request and only asks for what is needed to approve the zoning permit application on file, to add the word Young in front of Ace Hardware. And also notify the public that they are a locally owned and operated business, which the applicant claims would complement the character of the established commercial corridor. The evidentiary hearing was properly noticed. Public notice letters were mailed to adjacent property owners and the applicant on July 20, 2026. Public notice sign was posted on the subject property the same day, and legal advertisements ran in the Hendersonville Lightning on July 29th and August 5th, 2026. Staff would like to enter into the record the following attachments. Attachment A, the variance application submitted July 13th, 2026. Attachment B, the code ordinance reference for signs permitted in MRGB, neighborhood commercial, light industrial, and mixed-use zoning districts. Attachment C, subject property GIS aerial image. Attachment D, the site plan package with scale drawings for the proposed signage. Attachment E, certificate of mailing for the public notice letter dated July 2026. With that, that concludes staff's report.
Thank you. I'd like to recognize the applicant if you agree or object to the planning board, planning staff exhibits. Questions from the board to the planning and zoning staff?
No.
It's my understanding when this sign was put up, it was in compliance.
Which signs are you referencing to? What's proposed or what is existing?
What's existing? That's what we're talking about, right? The
Correct.
existing signs,
Correct. So
the whole shopping center or just on Ace Hardware?
just on the facade of the tenant space for Ace Hardware. So the front, the front area of the surface area of Ace Hardware, not the entire shopping center.
So when that was constructed, it was in compliance with the ordinances and rules we had at the time.
Correct.
Any other questions?
No. Now they just want to add Young, correct?
Yes, ma'am.
And so adding Young to the existing sign makes the sign too big.
Correct. By about 15.19 square feet.
Okay, that's the part I meant. Okay,
Okay.
sorry, I
Yeah.
missed. That explains
I got you.
over here.
Told you that.
Mhm.
Yeah. Any other questions for zoning staff?
No.
Like to recognize the applicant to present evidence and testimony. You can come up to the microphone.
Last but not least, thank you, for your time tonight. I am Eric Young, owner of Young Ace Hardware. I'm also a resident in Mills River, so I'm not just a business owner coming in here wanting to add my name to it. I live here, lived here almost 10 years. I don't know that I need to say a whole lot after what Mr. Webb read. But to, I guess, answer what you brought up, yeah, the gist of it is we're wanting to add the word young to our existing signage. When we opened the business, we started our business back in 2004. Weaverville, we've grown to a handful of stores in the area. Mills River was opened in 2015. We did not brand ourselves as Young Ace Hardware back then. We just called ourselves Ace Hardware. And since that time, other Ace Hardware families that come into the area, it's become important to us to brand ourselves as individually owned and operated. And we think adding the word young to that will have impact on it. It's important. If you've seen any of our advertisements, everything that we have out there now says Young Ace Hardware on it. And I am slowly, as I can, changing each store signage to try to say young. I imagine that's an expensive feat, so we can't do it all at once. But we just remodeled the Mills River store. If you haven't been in it, it went through a major remodel, and we figured now is a good time to do that. Happy to answer any questions.
Any questions? What do you have?
None.
No.
No, thank you.
Thank you.
Recognize any person that's standing to present evidence or testimony. If none, preliminary discussion with the board with input from any party or witness.
I do have one clarifying question. Under the common signage plan, it doesn't apply to them right now, but if it did, you're saying this would be allowed to that plan? That's
UDO.
UDO.
No, sir, under
UDO,
existing.
So we don't have a common signage plan for the UDO got shot down.
No, sir, that is part of the current sign ordinance.
Okay, so
Adopted, that specific code reference was adopted in 2017 after the existing sign was installed and the Ingalls Shopping Center was constructed.
But if we had adopted the UDO, the addition of that would have fallen in that and it would have not been an issue. That correct? If we
Correct.
adopted-
As adopted, the applicant wouldn't have had to, needed to come apply for a variance for the additional wall signage.
I guess what I'm asking is, right here it says the 150 SF minimum can be waived as part of the common signage plan.
Correct, and there is no common signage planned because because the sign, the shopping center did not have a common signage plan because there were no provisions for a common signage
My
plan.
question is, if it had one, then this would be allowed.
Yes, sir.
Mr.
Up
Young-
to 10%. Sorry, sir. Yeah.
Mr. Young, do you have is there a Ace Hardware presence on the large pylon sign that out there that fronts, Boston Highway?
There's multiple pylon signs for the shopping center.
Mhm.
There's the Big Ingles one, and then there's one down towards our space that has us, the dentist, Mills, and Papa John's on it. Yes, we do have panels on that.
Just curious.
Part of this plan is to replace those panels. That's not in these documents because that doesn't require any sort of variance. But-
Thank you.
Yep.
Right? Any other questions?
No.
Then I would like to entertain a motion to close the evidence portion of this hearing.
Motion to close the evidentiary portion of this hearing.
Second.
All in favor? Deliberation of the board, consideration of all the factors set out in the ordinance.
In the
Well, it's not, can't adopt it. Yeah.
I make a motion that unnecessary hardship would result from the strict application of the ordinance because it would cost the business. It would cause the business to incur unnecessary expenses by having to replace the entire sign.
Like to propose an amendment.
Go ahead. Amended motion.
I don't know that I'm right. I'd like to add that it otherwise would be allowed if common signage plan applied.
If the shopping center had,
The common the signage plan, it was, I guess it was built before the common.
no, the shopping center had to have one in order for that to apply, and they do not.
May I? May I suggest that you wait until spirit and your question comes up?
Sounds perfect.
Okay. Motion still pending. I guess second,
Second it.
as in,
Seconded as originally.
all in favor?
Aye.
Aye.
Motion passes with 5 votes.
I have a motion. I make a motion of hardship, I make the motion that hardship results from conditions that are peculiar to the property. Due to the fact that it's unique to the property because the shopping center building is substantially set back from Boston Highway. And it is diminished because the Ingalls gas station fuel canopy is located in front of the shopping center building, partially obstructing the transport.
I second.
All in favor?
Aye.
Aye.
Any opposed? Motion passes with 5 votes.
I make a motion that the hardship did not result from actions taken by the applicant or property owner because at the time the initial sign went up, they were going by what was allowed. in order to extend the sign, they need to get another permit.
Okay,
Yeah.
Okay, I second.
all in favor?
Aye.
Aye.
5 votes in favor, passes. Yours.
I make a motion that the requested variance is consistent with the spirit, purpose, and intent of the ordinance, such that public safety is secured and substantial justice achieved, because I really don't quite understand that's on the signage plan for some reason, going over my head, but I'm going to put that part on my motion. That it would be allowed if shopping center had a common sign or common signage.
I second.
All in favor of second? All in favor, say aye.
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 Second.
Any opposed?
I
Passes
make a
with 5
motion,
votes.
sorry, I make a motion, we approve variance 26-3.
I second.
All in favor?
Aye.
Aye.
Any opposed? Variance passed. I'd like to entertain a motion to close and adjourn the evidentiary hearing.
So moved.
Second.
All in favor?
Aye.
I'd like to entertain the motion, no, I'd like to announce the next regular scheduled meeting is October 13th. That's my birthday.
Happy birthday, Bert.
And
Need a cake.
next, I would like to entertain a motion to adjourn.
Adjourn. Thought we did that.
Adjourn.
I second.
All in favor?
Aye.
Thank you. Appreciate it. Done. This certificate